Welcome to the People's Law School. My name is John Brinkley, and I'm a member of the Alabama Association of Justice. I'm also a member of the Huntsville-Madison County Bar Association, and it is my pleasure to be able to introduce tonight one of the judges of the 23rd Judicial Circuit, Alison Strickland Austin. She is one of 10 children to Dr. and Miss Strickland. Her father has probably put braces on some member of your family at one point or another. I unfortunately did go to a different orthodontist, and I had braces twice, which is something we don't bring up at my house often. Judge Austin is a district court judge at present, and she handles a host of different cases, many of which you may not ever get to hear about. These are cases involving children and the Department of Human Resources, and some of the other child support issues that go along with juvenile cases. She hears all different types of cases ranging from misdemeanors all the way up to felonies. Those cases, once they do become felonies, go up to the circuit court level once she's had them bound over to the grand jury for consideration. Judge Austin has been a graduate of the Auburn University, where she went on to the University of Alabama Law School. From there, she became an assistant district attorney for Tim Morgan here with Madison County, and from there went on to the United States Attorney's Office. After that, she was able to come back and oversee cases here in Madison County. It's my pleasure to introduce Alison Strickland Austin.
Thank you very much. I'm very honored to be here to speak to you. What I want to do is kind of give you a general overview of the judges in the state, what each of the different jurisdictions are for each of the courts, and then bring you back to district court and what I do in district court. As Mr. Brinkley told you, I was an assistant district attorney here in Madison County for 5 years, where I prosecuted child abuse, sexual assault, and violent crime. I then went to the United States Attorney's Office here in the Northern District of Alabama. I was based out of the Huntsville branch office. Home base was in Birmingham, and prosecuted a host of federal crimes. I did that for 8 years, and then was appointed by Governor Riley in March of 2010 to the district court bench to fill the vacancy left when Judge Odell was appointed to the circuit bench. I ran for election in November of 2010 and was elected unopposed, thank goodness. What I've handed out to you is an outline of our court system. I'm not going to go through it page by page, but I do want to hit some of the high points. First is what types of courts that we have here in the state. Everyone knows that the highest court, the court of last resort, is the Alabama Supreme Court. That court has appellate jurisdiction. It's comprised of 9 justices, which includes the Chief Justice. That appellate jurisdiction is that they can hear cases that are appealed to them from a lower court. Below the Supreme Court, you have the Court of Civil Appeals and the Court of Criminal Appeals. Both of these courts also have appellate jurisdiction, which means these matters are appealed to them from a lower court. As their name states, the Court of Civil Appeals hears civil cases that are appealed to them. The Court of Criminal Appeals will hear criminal cases that are appealed to them. Each of these 2 appellate courts contain 5 justices apiece, which are elected. All of these justices, whether it's the Supreme Court, the Court of Civil Appeals, or the Court of Criminal Appeals, all of those justices are elected from a statewide election. Underneath those appellate courts, you have the circuit courts. These are courts of general jurisdiction. Currently, there's 41 circuits, and there's 143 elected judges for those circuits. Underneath the general jurisdiction of circuit courts, you have courts of limited jurisdiction. These courts of limited jurisdiction include probate court, municipal court, district court, and juvenile court. I'll go through each of the different types of cases that we handle and that the other courts handle. But know that probate court, there's 68 elected judges for the 68 courts for probate court. In district court, we have 67 districts, and there's 103 currently. The figures in your book are a little off, but there's 103 elected judges that are district judges in the state. Municipal courts, there are 279 appointed municipal judges here throughout the state. What qualifies an individual to be a judge? What's interesting is that the Constitution in 1819 established the judicial department as one of the three branches. We were a separate judicial department, and it was comprised of just the Supreme Court and circuit courts. The circuit courts were mandated pursuant to that Constitution to, each county was to have a circuit court. Judges of the circuit courts would sit at the Supreme Court. And that was the first 12 years of our Alabama judiciary. The judges that were provided for under this plan were elected by the General Assembly, and they sat, quote, for life during good behavior, whatever that means. And they could not serve past their 70th birthday or their 70th year of age. The first term of the Supreme Court was held on May 10th of 1820. But the Judicial Article Implementation Act, adopted by the Alabama legislature on October 9th, 1975, brought about the most profound changes, and one of which said that judges had to be lawyers in the state. They were required to be lawyers. It also brought the canons of judicial ethics, which kind of serve as judges' guideposts for behavior and conduct. So qualifications first for how you can become a judge and what you need to do is that all judges and judges, with the exception of the probate judge, must be licensed to practice in the state of Alabama. Also, in order to be appointed to the position, you must reside in the county in which you are going to be performing your duties for 12 months prior to the appointment or your election, and you must stay in that county during the course of your term of office. All judges, with the exception of municipal court judges, are elected to serve 6-year terms. Municipal judges are appointed by the governing body of the municipality. Full-time municipal judges are appointed to 4-year terms. Part-time municipal judges are appointed to 2-year terms. Vacancies in the positions of judges, either by someone retiring, are filled by appointment through the governor. That's how I got appointed, was from Governor Riley appointing me. We went through a whole commission process where interested attorneys made application. We all were interviewed in front of a commission here locally in Madison County, and the commission sends 3 names down to the governor's office. We were interviewed by the governor's office, and then the governor selected one of the 3 candidates to fill the position. Appointments are in that filled position until the next upcoming election, and then they have to run. So if you're appointed to fill, we're 6-year terms. If I was appointed in year 1, but there's an election that's going to occur every 2 years, I would have to run in that next general election. I couldn't serve out a 6-year term. The canons of judicial ethics, these are the standards of professionalism by which the judiciary is maintained. What happens if you think that there is misconduct of professionalism or wrongdoing on behalf of a judge? A complaint is made to the Judicial Inquiry Commission, or in other words, JIC. This commission will conduct investigations into verified complaints, filed either by a member of the public or a member of the commission, and only upon an affirmative vote of a majority of all members of the commission at a duly called meeting. So this investigation will only be conducted if the commission itself reviews the verified complaint and the majority of the members decide to do so. If they do find a reasonable basis exists to charge a judge with a violation of any canon of judicial ethics, misconduct in office, failure to perform duties, or if the judge is physically or mentally unable to perform the duties of the office, then the commission will file a complaint with the Court of the Judiciary. The Court of the Judiciary will then convene a public hearing, and they're authorized to remove a judge from office, suspend a judge without pay, or censure a judge for violations of his or her duties if they find that the canons have been violated. The Court of the Judiciary is comprised of an appellate judge, 2 circuit judges, a district judge, 2 members of the state bar, 2 non-lawyers appointed by the governor, and an individual appointed by the lieutenant governor with Senate confirmation. And any decisions of the judiciary, the court of the judiciary, may be appealed directly to the Supreme Court for review. Again, I'm giving you just broad, wide-sweeping overviews of all of this information because I want to get back to what district court does here in Madison County and present to you some cases and ideas. But I think it's important for you to know the overlapping area of all the different elements in the state and what occurs. All right, so let's go back and review the courts of limited jurisdiction that I reviewed with you earlier. And we'll start with municipal courts. Does everybody know what a municipal court is? We're sitting in one here today. They exercise jurisdiction over prosecutions for violations of municipal ordinances, which occur within the city limits and police jurisdiction of the municipality. They may exercise jurisdictions over violations of Alabama law if the state law has been incorporated in the municipality's ordinances. So if an individual is charged in the city of Madison for assault in the 3rd degree, that's a state charge. It's by statute. It can be prosecuted in the city of Madison in their municipal court because they've adopted the state laws as part of a municipal ordinance. Probate courts are also considered a part of the state court system, but what is interesting about a probate court is that those courts are not funded by the state budget. They are funded separately through the county. Probate courts handle matters involving the probate of wills, the administration of estates of those who die without a will, property rights of widows, and adoption proceedings. They're also responsible for recording of all land partitions and sales within the county and the maintenance of indexes showing where and when deeds, mortgages, and other instruments of conveyance are recorded. District courts, the 3rd court of limited jurisdiction. That's what I do. What I consider district court, we're often the first time anyone has had any exposure to the court system. So I look at what I do as exceptionally important because it's an opportunity for me hopefully to make an impact on some young person's life or some individual that's their first encounter with the law. A 20-year-old that comes in front of me and has been charged with possession of marijuana. They're scared, they're nervous, they think I'm going to judge them, they think I automatically assume that they're a bad egg because they have this charge. What I try to do is to instill a message into these young people that come in front of me that you are not defined by any mistakes that you make. I challenge them to find anyone that has never made a mistake in their life. It's not possible, to even include myself. But what I try to share with these young people that come in front of me is that character is built by your response to adversity. That's what defines true character. That's what defines in these young men who come in for child support or non-payment of child support. I stress to them, you are the one that's responsible for defining who you want to be as a man, who you want to be as a father, what kind of character you want to show. How are you going to respond to this adversity and this challenge? Because all of us has faced it. It's just a matter of how you respond to it. So that's what I instill upon myself to try to hopefully make a difference in these young people. I also hear child custody cases, and this is another thing that I frequently tell my young parents of children that come in. If you love your child more than you hate the other person, more than the water under that bridge, more than the river, raging river flowing under that bridge, if you love your child more than that, you will do the right thing when it comes to your child. You will not talk bad about the other parent. You will treat that child, smother him with love. You'll let that child know they are the most important thing, regardless of how you feel about their mother or their father. And that's an important lesson that I try to take and to give to these individuals. District court for me is the lessons that I like to give to district court. to try to instill to all these individuals who come in for the first time. But back to jurisdiction. We have original jurisdiction over misdemeanors. Does everybody know what a misdemeanor is? Okay, there's 3 different classes of misdemeanor: a Class A misdemeanor, a Class B misdemeanor, and a Class C misdemeanor. These crimes are differentiated by punishment. A Class A misdemeanor is punishable by up to 1 year imprisonment. A Class B misdemeanor, the statutory maximum penalty is up to 6 months imprisonment. A Class C misdemeanor, the statutory maximum penalty is up to 3 months imprisonment. That is what we have jurisdiction over, and those are the types of cases that we can hear. We also can hold preliminary hearings in felony prosecutions. A preliminary hearing is basically a probable cause hearing. Is there enough probable cause to believe that this individual has committed the crime for which he's been charged? If I find that there is sufficient probable cause, then I bind the matter over to the grand jury for consideration. I'll get into more detail in a minute with that one. We also have jurisdiction over various civil cases. We have a district civil docket. That's where the money damages or the amount in controversy is less than $10,000. We also handle a small claims docket where the amount in controversy is less than $3,000. We also, here in Madison County, handle juvenile cases, juvenile dependency cases, and juvenile delinquency cases. The juvenile court is the 4th area that I just went over previously of limited jurisdiction. That's jurisdiction over children, usually under the age of 18. And this is why we have jurisdiction over them, because they're either delinquent, dependent, or in need of supervision. Delinquent is when a petition is filed against a juvenile alleging that they've committed a crime. Dependency is either when the Department of Human Resources takes someone's child from a parent or a custodian because they say that that parent or custodian is unable or unwilling to discharge their responsibilities for that child. The other way that we get dependency petitions is through private parties, grandparents who are filing a petition on their own behalf to get custody of their grandchild because their son or daughter is on drugs, is homeless, is living with someone who has multiple felony convictions and is a drug user, a variety of different circumstances. But we get these private petitions where they're alleging, and it's typically grandparents, but I do have aunts, uncles, cousins, neighbors that are filing petitions alleging that a child is dependent, that the parent is unable or unwilling to discharge their responsibilities towards that child. Juvenile proceedings, unlike any other proceedings that we have, are confidential and they're not open to the public. So you'll see a sign over our doors that say confidential hearing is underway, and no individuals outside of the immediate parties to that action can come in the courtroom and be a part of that proceeding. Circuit courts are courts of general jurisdiction. There's 67 counties in Alabama, which are divided into 41 judicial circuits, and each of these circuits will consist of anywhere from 1 to 5 counties. Our circuit is just Madison County. You have some smaller areas that will combine 3 different counties to make a judicial circuit. Circuit courts have jurisdiction over civil matters where the amount in controversy exceeds $10,000. They also have jurisdiction over felony cases. Now there's 3 different types of classification of felony offenses which they'll maintain jurisdiction over. There's a Class A felony, a Class B felony, and a Class C felony. Again, what differentiates these different classes besides the elements of each statute is the punishment. A Class A felony is punishable by a term of imprisonment of 10 years to life. A Class B felony is punishable by a term of imprisonment of 2 to 20 years. And a Class C felony is punishable by a term of imprisonment of up to 10 years. Now, what differentiates what's going to be a Class A felony versus a misdemeanor? It's the elements of that crime that's charged. For example, rape in the first degree is a Class A felony. The elements of rape in the first degree, which is a Class A felony, is sexual intercourse either by forcible compulsion, which is where someone forces themselves, and against that individual victim's earnest resistance, they force themselves on them. The second way you can have rape in the first degree, that Class A felony, is it's sexual intercourse when someone is incapable of consent by being mentally incapacitated or physically helpless. And the third way you can have that Class A felony crime is sexual intercourse when the defendant or perpetrator is at least 16 years of age or older, and the victim is less than 12 years of age. Now that describes your Class A felony, which would be heard in circuit court. Rape in the second degree is the Class B felony, punishable by a term of imprisonment of 2 to 20 years. There's two ways that can be committed, that crime. One, the perpetrator is 16 years of age, and the victim is between the age of 16 and 12, and there's at least 2 years age difference between the defendant and the victim. Or two, the victim is incapable of consent by virtue of being mentally defective. The third crime that you could have, which I would have jurisdiction over, is a Class A misdemeanor, and it's called sexual misconduct. That crime is committed when someone engages in sexual intercourse without the victim's consent in any circumstance other than the circumstances I've already described for you. So it's sort of the catch-all provision, or where consent was obtained by fraud. So that's the Class A misdemeanor, which then would come to me. So that's kind of how different crimes are allocated to the different courts, either district or circuit. Now, circuit courts also exercise appellate jurisdiction from any cases that are appealed from district court or municipal court. Those appeals that are then appealed up to circuit court can be either tried with a jury or without a jury. But either way, those trials are de novo. They're fresh, they're anew. It's a new trial to them. So if I have an individual that comes in front of me charged with sexual misconduct and I find him guilty, and they appeal it to circuit court, they can choose. Do I want a jury trial, or do I want just the circuit judge to hear it? And that it is a trial de novo. So let's kind of go through how I get a case and what different processes occur. I'm going to use an example for a civil case regarding a landlord that is owed money from a tenant for back rent or a back lease. This is a typical complaint that I hear because I handle an eviction docket every Thursday, and money claims are often a part of it. So that process begins when you have the dispute. Then you have the landlord who files a complaint with the clerk's office, specifying what is due and owing, the amount of money that's due and owing, and it's for back rent or an unpaid rental amount pursuant to a lease. The clerk's office will then issue the summons with a copy of the complaint to be sent to the sheriff's department for service on the defendant. If the amount of money that's being sued for is $50,000, that action will be filed in circuit court. In the clerk's office, there's a circuit division. They'll accept that complaint. If the amount that's being sued for is $8,500, that would be on my district civil docket. It would be in district court. If the amount sued for is $2,000, that would go to small claims court. Now here's the differences and some of the similarities between them. Once that defendant is served with a copy of the summons, they have an opportunity in which to answer that complaint. In district court, they have 14 days in which to file an answer. In circuit court, they have 30 days in which to file an answer. If they fail to file an answer within that time period, then the plaintiff can file for a default judgment. It's when they go to the clerk's office and file out a form saying that this is he's been properly served, the 14 days has passed, they fail to file an answer, he's not in the military, he or she is not in the military, because that's a separate action, the Civil Members Relief Act, Civil Service Members Relief Act, and this is the amount of money. They swear to it, it's notarized, and then it comes to the judge's office. We can either grant it or we can have a hearing on the default judgment if we have questions about the amount of money or damages that are being sought. Once that default judgment is entered, the defendant will have 14 days in which to appeal, even a default judgment, to circuit court if you're talking about a district civil or small claims matter. If they fail to appeal within the 14-day time period, then the plaintiff can secure satisfaction of the money judgment. And this is something that I'm frequently asked. And I've actually heard in eviction dockets from mom and pops who are landlords, I have all of these money judgments, and they were thinking somebody else was going to do something to secure that satisfaction of that money judgment. It's the plaintiff's responsibility. The plaintiff has to find out where the defendant lives or where the defendant works so that they can file garnishments. They have to find out whether there's property that's unencumbered so that they can file liens to secure satisfaction of that judgment. And then once that judgment is completely satisfied, it's the plaintiff's responsibility to file with the courts a satisfaction of judgment form to let them know that that judgment has been satisfied. Some other important differences that can occur in the civil case process between district court and circuit court is that if the defendant answers within the appropriate time, there's several different answers that they can file, and that's applicable in both. They can file an answer denying the claim in its entirety. They can admit a portion of the claim and deny the rest. They can file a counterclaim. A counterclaim is when they allege that the plaintiff owes them money. So then the plaintiff will become a counterclaim defendant. Or they can file a cross-claim where that defendant alleges, I'm not responsible, it's this third party, and bring them into the action. The counterclaim or the cross-complaint, they have to be served. We have to go through the whole proper process, the answer on behalf of the counterclaim defendant who was the plaintiff. But once we have that all resolved and answers are filed, we'll set the matter for trial. There can be some discovery that can occur, and that's true with both circuit court and district civil. Discovery can be requests for depositions. It can be interrogatories, which are written questions that either counsel or either defendant pro se or pro se plaintiff, which means they don't have an attorney representing them, can ask that these questions be answered. Or they can request production of documents. In district court, you've got to receive permission from the court to conduct this discovery. The important difference is in small claims court, which is what I told you, if the amount in controversy is less than $3,000, the court cannot order exchange of information pretrial in small claims. You can request it, but I often get pro se motions where an individual is asking that I order or compel the other party to answer their discovery. I can't do that. The rules of small claims court prohibit me from ordering that. Once discovery is complete, you can have in circuit court pretrial conferences. You can investigate whether mediation or arbitration is appropriate, and then we'll proceed to trial. And I'm going to go through the trial process in our court in a minute. And then a verdict is rendered. In civil cases, it's either a judgment in favor of the plaintiff or a judgment in favor of the defendant. Okay. Where is the appropriate court and what venue? Jurisdiction I've already reviewed with you, and that's which court should hear the matter, and that's determined by the amount in controversy in civil matters. Venue refers to the county in which the action's to be held. In criminal cases, the venue for that case is where the crime occurred. In civil cases, it's typically where the defendant resides or where the act complained of occurred. So often I'll have these cases that are involving County Line Road, where Madison and Limestone County interchange and a tree or some other landscaping was damaged by an individual, and if the defendant resides in Limestone County, the defendant will file what is called a motion to change venue, wanting to change the suit from Madison County small claims or district court to Limestone County. And when that happens, the whole case gets transferred and Limestone County Court will take care of it. Okay? All right, now we're going to go through quickly the criminal process and what occurs with a case when it comes before me and how it comes before me. I told you that I handle preliminary hearings with felony cases, which are the probable cause hearings. So a crime is committed. When that crime is committed, the individual can be arrested with a warrant or without a warrant. If they're arrested pursuant to a warrant, then a 72-hour hearing will be held where the defendant will be advised of their rights, where you ensure that that individual is the individual that's been charged in the warrant, and then they're informed of their bail amount. The 72-hour hearing has to occur. If the 72-hour hearing does not occur, then what you'll have happen is a defense attorney will very wisely, very astutely, because this is the law, file a motion to have the defendant released on the least amount of bond that there is, and that's their right. They have to have the 72-hour hearing or they're released from whatever the lesser amount of the bail schedule is for that crime that's charged. After the 72-hour hearing, the attorney then will request a preliminary hearing. At the preliminary hearing, there's a determination to be made by the district court judge as to whether there's sufficient probable cause or reasonable grounds to believe that the individual committed the crime. If I find that there is, then I bind the matter over to grand jury for consideration. If I don't, then the case is dismissed against the individual. The district attorney's office can decide that they still want to present the case to the grand jury directly. That's their prerogative. They can do that, but I've dismissed it at this particular stage. That is where district court, that's our level of involvement with felony cases. Oftentimes, we also hear before a case is presented to grand jury whether to revoke an individual's bond, because district courts will maintain jurisdiction over felony cases until they're indicted by the grand jury. So you'll see in the papers sometimes a hearing on a bond revocation motion that was filed by the state. We entertain those. Motions to increase the bond, motions to add conditions to the bond, such as putting them on an ankle bracelet, taking away passports, restricting travel. All of those are heard in the district court level. If a felony case is presented to a grand jury, the grand jury is composed of 18 citizens, and they will decide whether to return an indictment, if there's sufficient grounds to return an indictment so that the individual can be tried or not. Now, as I said before, sometimes cases, an individual is not arrested on an arrest warrant or with a complaint. Sometimes the district attorney's office will directly present a case to the grand jury for their consideration. And the grand jury will determine whether to issue an indictment and the defendant will be picked up and arrested on that warrant from that indictment or not. Now, at grand jury, these 18 individuals will hear a case that's presented by the district attorney's office. The defendant does not have a right to be present. It's just the district attorney's evidence and their witnesses that they choose to call. There's no recording of the proceedings that occur with grand jury. If an indictment is returned, then the individual will either, if they've already been arrested, they'll proceed to arraignment in circuit court, where they will enter a plea of guilty or not guilty. If they had not previously been arrested, then they'll be arrested on that charge, and then they'll go to the arraignment in circuit court to plead guilty or not guilty. Or the grand jury can return what's called a no bill, and the case is dismissed. If the individual pleads guilty, the circuit court will set it for a sentencing hearing at a later date. If the individual pleads not guilty, we'll proceed to trial, where a jury will return a verdict of either guilty or not guilty. If they return a verdict of guilty, it'll be set for a sentencing hearing at a later date. Sentencing options can be either probation or a suspended imprisonment term, or going to the Department of Corrections. If they violate any conditions of their probation, they then can be sent down as an option to the Department of Corrections to serve their sentence. They can also appeal their cases to the Court of Criminal Appeals. Now let me talk to you a little bit about what happens, because oftentimes about how a case is heard in front of a district court judge. I hear all the time in eviction cases and small claims cases, individuals, because they're pro se. The vast majority of the cases that I hear are pro se, which is just an individual versus an individual. They don't have attorneys representing them. And they come in front of me and are very apologetic. I don't know what I'm doing. I don't understand what I'm supposed to be doing. I often tell them, you didn't stay at a Holiday Inn Express. I don't expect you to know everything that attorneys know from going to law school. It's okay. I'll walk you through the process. So here's what happens when a case is presented to me. If it's a civil case, the burden is on the plaintiff to prove their action. They brought the complaint. So we'll begin with the plaintiff's case. The plaintiff can provide any witnesses through testimony, any evidence that he or she wishes to present to me to review. After each witness testifies, they're subject to cross-examination by the defendant. At the conclusion of the plaintiff's case, we then move to the defendant's case. The defendant can present any witnesses or testimony, exhibits, etc., that they wish to present. The same rules apply. After each of the defendant's witnesses testify, they're subject to cross-examination by the plaintiff. I caution both sides. I'm going to give both of you an opportunity in rebuttal to say anything you want to say regarding what any of the other individuals on the opposing side testifies to. So we'll move to the rebuttal of the plaintiff and the rebuttal case of the defendant. And we'll continue doing that until they rest. When they rest, then I will make my ruling. Judgment for the plaintiff or judgment for the defendant. Sometimes what can occur is you can have a motion for a directed verdict. That is made by a defendant after the conclusion of the plaintiff's case, where the defendant says they haven't even proved their case. It should be dismissed without having to even present the defendant's case. In circuit court, it's the same way, except you're in front of a jury. So you've got some additional steps. There's voir dire, or selecting a jury. That's where the attorneys are able to ask the questions of a jury pool to try to pick a fair and impartial jury to hear their case. That was often my favorite part of the case. I loved interacting with the jury. After the jury is impaneled, and it can be 12 members, alternates, they can agree to a lesser number, then you'll have opening statements by the attorneys. Now, these opening statements are not evidence. Judges will always caution the jury that opening statements are not evidence, but it's the attorney's prologue for what the case is going to be. They're describing what they anticipate you're going to hear as a juror. So the plaintiff will start with their opening statements because they brought the complaint. The defendant will then proceed with their opening statements. And then we begin with the plaintiff's case. Similar to as it is in district court, they will present each of their witnesses. They'll be subject to cross-examination by defense counsel. At the conclusion of the plaintiff's case, the defense counsel may make a motion for a directed verdict, alleging that the plaintiff has failed to prove their claim. If the motion for directed verdict is denied, then we'll move to the defendant's case, again subject to cross-examination. At the conclusion of the case, after each side has had an opportunity for rebuttal, then you'll get closing arguments. The judge will then charge the jury as to the law. The jury will deliberate and return a verdict. In criminal cases, it's much the same way, both in district court and in circuit court. In district court, the state will have an assistant district attorney in my courtroom who will present their case first because they bear the burden of proof beyond a reasonable doubt that the defendant is guilty of whatever crime has been charged. In district court, those cases are sometimes heard pro se, where the defendant will not hire an attorney to represent themselves. They have the right, if they're unable to afford an attorney and they're to make application for a court-appointed attorney. That's if they're found indigent. If they're found indigent, the court can appoint an attorney to represent a defendant in a criminal case. The defendant will have to pay for the services of that attorney at the conclusion of the case. That attorney's fees will be made part of court costs, so it's not a free attorney. But coming back to the trial process, in criminal cases in district court, it's the same, very similar to how it is with civil cases. We'll begin with the state to prove their case. But when we get to the conclusion of the state's case, the defendant can make a motion for acquittal, same if the state failed to prove their case. The defendant doesn't have to testify, can't be required to testify, can't be made to incriminate himself. That's their right. So they're under no obligation to provide any kind of case whatsoever. If they do choose to testify, or if they present any witnesses, they're subject to cross-examination by the prosecutor. And then once they'll both have an opportunity for rebuttal, and at the conclusion, then I'll render a verdict of either finding the defendant guilty or not guilty. In district court, usually we go immediately into the sentencing phase. I'll take the recommendation from the prosecutor. I'll ask the defendant to make any statements that he wishes to make with respect to sentencing, he or she, and then I'll impose sentencing in that matter. In circuit court, again, the same sort of process occurs with voir dire, opening statements, closing statements. We begin and end with the plaintiff or with the state in closing statements because they have the burden of proof. And now I'm going very quickly. It's a lot of information. They can appeal their cases as well. What I really want to talk to you about now is the juvenile process and kind of explain to you what occurs with juvenile delinquency and dependency cases. In juvenile delinquency cases, a complaint is filed with a juvenile intake officer. That complaint could be dismissed at that particular point in time, or the juvenile can be detained at a detention hearing, which needs to occur within 72 hours. At that detention hearing, the juvenile can either be released back to their parent or detained in the facility, or released to the parent under conditions, or released to a relative. Once the petition comes in front of me, I have an adjudication hearing. So in criminal cases with adults, I find that the individual is, and I ask, do you wish to plead guilty or not guilty? With juveniles, I ask, do you admit or deny the petition that's been filed in your case? If they admit to the petition, then I find that they are a delinquent child. If they deny the petition, then we'll set it for a hearing, a trial, and if I find that they are a delinquent child, I find that the allegations of the petitions are met, then my finding is that they are a delinquent child. I'll ask both sides for their sentencing recommendations, and then I'll impose sentencing. The sentencing can either be probation, or they can be sent to the Department of Youth Services at Mount Meigs. Another option that's available to me in juvenile delinquency cases is what's called a consent decree. A consent decree is an agreement between myself and the juvenile's parents, where they agreed to abide by certain terms and conditions, to not break curfew, to stay on an ankle monitor, to complete any drug outpatient treatment, etc. If they successfully complete the terms and conditions of that consent decree, which are monitored by a probation officer, a juvenile probation officer, then the petition is dismissed against them. If they violate the terms and conditions of the consent decree, then the case is brought back before me for them to either admit or deny the allegations contained in the petition. Dependency cases, I gave you a brief overview of these dependency petitions earlier about how these dependency cases can be brought before me, either through the Madison County Department of Human Resources or through a private petition. What happens if these cases are brought through the Madison County Department of Human Resources? If they're wanting to take children away from the care and custody of the parents, they'll have to file a shelter care petition. That petition has to be heard, in which they allege that there's emergency circumstances necessitating the need to take these children out of the care and custody of their parents and place them either in the custody of the department, where they'll be placed with a foster home, or with a relative or some other individual. After the shelter care hearing, then we'll have an adjudication hearing in front of myself. Now, adjudication is just to determine whether that child is dependent or not. If the child is not found to be dependent, the case is closed. It's dismissed. I only have jurisdiction in juvenile court if the child is dependent. If I find that the child is dependent, then we'll move to the dispositional phase as to what needs to occur with this child. Will this child be placed in the temporary legal custody of the Madison County Department of Human Resources? Will they be placed with a relative? Will they be placed with a neighbor? Will they be returned to their parent under certain conditions and stipulations? When the Madison County Department of Human Resources brings a petition, they have to provide reasonable efforts to the parents to try to reunify them with the parent. So the hearing at the adjudication and dispositional phase doesn't end. I'll continue to have review hearings every 60 days, 90 days, 30 days, whichever time period I choose, so I can evaluate whether that parent is doing what they're supposed to be doing. Are they taking their drug screens? Are they going to drug treatment? Are they finding housing? Do they have utilities? Do they have the ability to pay for food for this child? There's a variety of different things, but the department needs to provide these services to these parents. If the department is providing these services and I find that these parents are not complying, then at a point I will have a permanency hearing whereby I will vest legal and physical custody with a relative, and then we'll close the case to further court review. If there's no relative that's willing and able to take the child, then the department will file a termination of parental rights hearing. And those are difficult cases where we have a hearing as to whether we need to terminate those parental rights, place that child in the permanent legal custody of the Department of Human Resources for adoption, planning, and purposes. And it's, for me, being from Madison County, it's amazing to see the types of cases that I see. And it's heartbreaking at times to see parents who would rather go to a methadone clinic and not have any housing and not have any utilities and not having any food, and having the police department go out to their home and the 2-year-old is in a diaper outside with no parental supervision. It happens all the time. Private petitions can also be brought. When a private petition is brought, much like with the department, I appoint what's called a guardian ad litem. It's an attorney here in Madison County that will represent the child. I want to ensure in these dependency cases I have as many eyes as possible on that case so that I am making the best decision, because this is a child's life. These are parents. I'm a parent of 5. I cannot imagine having my rights terminated from a child or having my child taken from me. We appoint CAJAs, court-appointed juvenile advocates, who are volunteers to be an extra eye on this case to ensure that everything's being done. I got the 10-minute sign. I want to make sure I'm telling you everything I need to tell you. Let's see. We often have cases that are brought back with dependency cases where custody is vested with a grandparent, and then the grandparent will file a year later to have custody returned back to the parent because they've gotten the drug treatment that they need. They've done what they need to do. Let me give you just basically now a very general overview of our caseload here in Madison County. I'm going to use 2012 statistics. In 2012, there were 33,560 filings, which our Madison County District Court, the 4 judges of us, handled. There were 35,787 actions taken. So some of those 30, you'll see that it's more than the filings, but there's pending cases. There's still holdover cases from the year prior that we're trying to still deal with. Breaking that number down, For criminal cases, we handled 8,200 criminal cases. We handled 14,360 traffic cases, 4,737 small claims cases, 3,507 district civil cases, 1,468 juvenile delinquency cases, 1,206 child support cases, and these child support cases can come either through the Department of Human Resources or from private petitions, but these involve child support, paternity, child custody. And then what's not included in these figures is our juvenile dependency cases. And I'm sorry, I don't have a statistic for you about how many juvenile dependency cases we heard. So our district court judges here, we're jack of all trades, but what I can tell you is I do it because I love it. My mom and my dad, and I'm going to embarrass them right here because they gave me that. They gave me the passion to want to selflessly give because that's what they did. They were the example for me. I mean, my mom raised 10 kids. I'm the second of 10. There's no twins, no nothing. And my father selflessly gave to his patients and to us as well. I can remember being at Auburn games and he would have one of his patients laying on the hood of the car trying to tighten a loose bracket. That's what I grew up and that's what I love. And it's only from their example and from my wonderful husband and his support that I'm passionate about doing it. My whole life's been public service and I welcome it, I love it, I enjoy it. I get up every morning and I'm not feeling like I'm going to a job. I'm going to something I truly, truly love. And I have a great staff there in the back of the courtroom. So thank you for giving me an opportunity to serve you. I am honored and it's a wonderful, wonderful experience. Yes, ma'am.
You have federal court experience.
Yes.
In case of a lawsuit filed under the ADA, who decides whether to publish or not to publish their case?
Can you repeat this question?
She was asking the ADA with who decides whether to publish or not to publish. Are you talking about appeals or who's going to handle it generally?
From the beginning.
From the beginning?
From the circuit court on. From the district court.
From the district court with federal court? I didn't have any dealings with that. I was in the reactive division. There's proactive, reactive division, so I handled criminal cases in the federal courts. We had a separate civil division that handled those types of cases, so my experience, unfortunately, doesn't delve into that avenue since I did bank robberies, drug trafficking, so that's what I did. I'm sorry, I don't have the ability to answer that question.
One more little question.
Yes?
The grand jury, does it have to be unanimous?
No. Well, it has to be unanimous. It doesn't have to be a majority, but there has to be a unanimous decision returned on whether to issue an indictment or not. And that also, let me tell you real quickly about the federal courts to show you the differences as well. We have 3 different districts here. We have a northern, middle, and southern district. And we're in the northern, which encompasses 36 counties, I believe. We have federal courthouses throughout the northern district. There's some in Decatur, Huntsville, Gadsden, Anniston, Florence, Birmingham, Tuscaloosa. These courthouses are located where the different divisions are. And typically the federal courts, they'll have the trials, they try to have them in a courthouse where they're taking the jurors, and they'll take them from whatever division, Northeastern Division, Southern Division, Middle Division within the Northern District to have their trials. So as a federal prosecutor, I was on the road a lot. I was traveling to Tuscaloosa to have a case that originated from Tuscaloosa to have the trial there. I was going to Florence. I was going to Gadsden. They have district court judges in the federal system that hear the case, that have jurisdiction to hear the crimes that are charged federally. They also have magistrate judges. The magistrate judges are similar to district judges. The magistrate judges will have suppression hearings to see whether evidence needs to be suppressed in any of these cases. They'll hear any misdemeanor cases that happen out on the arsenal or on any other federal property. So that's the 2 divisions that they have. The district court judges in the federal system are lifetime appointments. They're appointed by the president, and they are lifetime appointments. The magistrate judges are appointed by the district judges, and they serve for a specified period of time, and then they can come up for renewal. Okay. Yes, sir.
You mentioned children. You didn't mention those that have a handicap, a mental handicap, and or elderly who are suffering dementia. How are those handled?
Well, we have medically fragile children. We have individuals that are children that are born that the department will file petitions for that are considered medically fragile. Typically, those are circumstances wherein a mother was abusing substances throughout, and I have several of these cases where children are on breathing machines, they can't walk, they have spinal bifida, they can't eat. They're termed medically fragile. They end up going into, the department will file a petition to get custody of that child. They will go into a medically fragile licensed foster home, and they're treated much the same way. The Department of Human Resources has an adult division where they take complaints regarding adults that are mistreated, and they can file those petitions as well. We have a juvenile referee here in Madison County. We're very lucky to have one of those. And a juvenile referee is one that's appointed by the district judges and can hear certain kinds of cases. Statute will tell what type of cases that the juvenile referee can hear. But medically fragile children, children with mental handicaps are handled much the same way. We try to find the best facilities we can to help these children and ensure that they are being properly provided for, as well as the adults.
You used the word children, and I was looking for the age at which they no longer are considered a child.
Typically, the juvenile court will have jurisdiction up until they reach the age of 18, generally. Sometimes we'll go up to 21 when they're handled in the juvenile system. Mm-hmm.
The age in Alabama of adulthood 19?
Yes, but typically you're talking about different ways that the age applies, but in juvenile court, typically we have jurisdiction up until the child reaches the age of 18 in delinquency cases. Dependency cases, we can have jurisdiction over that child until they're 21.
Judge, thank you so much.
Thank you.